Namaskar. With today's case note, we shall try to understand what is judgment. What is judgment has been beautifully explained by Honorable Mr. Justice M.R. Shah, Honorable Judge, Supreme Court of India, in the case of Shakuntla Shukla versus State of Uttar Pradesh and another in Criminal Appeal number 876 of 2021. Let me take you to the relevant para of the judgment, where Honorable Mr. Justice M.R. Shah very beautifully explains the components of the judgment, how the body of the judgment should be, and what things are to be considered at the time of writing a judgment. Para 9.2. First of all, let us consider what is judgment. Judgment means a judicial opinion which tells the story of the case, what the case is about, how the court is resolving the case, and why. Judgment is defined as any decision given by a court on a question or questions of issue between the parties to a proceeding properly before court. It is also defined as a decision or the sentence of a court in a legal proceeding along with the reasoning of a judge which leads him to his decision. The term judgment is loosely used as judicial opinion or decision. Rosalind Atkinson J., Supreme Court of Queensland, in her speech once stated that there are four purposes for any judgment that is written. One, to spell out judge's own thoughts. Second, to explain your decisions to the parties. Third, to communicate the reasons for the decision to the public. And fourth, to provide reasons for an appeal court to consider. It is not adequate that a decision is accurate. It must also be reasonable, logical, and easily comprehensible. The judicial opinion is to be written in such a way that it elucidates in a convincing manner and proves the fact that the verdict is righteous and judicious. What the court says and how it says it is equally important as what the court decides. Every judgment contains four basic elements, and they are statement of material relevant facts, legal issues or questions, deliberations to reach a decision, and the ratio or conclusive decision. A judgment should be coherent, systematic, and logically organized. It should enable the reader to trace the fact to a logical conclusion on the basis of legal principles. It is pertinent to examine the important elements in a judgment in order to fully understand the art of reading a judgment. In the path of law, Holmes J. has stressed the insentient factors that persuade a judge. A judgment has to formulate findings of fact. It has to decide what the relevant principles of law are, and it has to apply those legal principles to the facts. The important elements of the judgment are caption, case number and citation, facts, issues, summary of arguments by both the parties, application of law, and final conclusive verdict. The judgment replicates the individuality of the judge, and therefore it is indispensable that it should be written with care and caution. The reasoning in the judgment should be intelligible and logical. Clarity and precision should be the goal. All conclusions should be supported by reasons duly recorded. The findings and directions should be precise and specific. Writing judgments is an art, though it involves skillful application of law and logic. We are conscious of the fact that judges may be overburdened with the pending cases and the areas, but at the same time, quality can never be sacrificed for quantity. Unless judgment is not in a precise manner, it would not have a sweeping impact. There are some judgments that eventually get overruled because of lack of clarity. Therefore, whenever a judgment is written, it should have clarity on facts, on submissions made on behalf of the rival parties, discussion on law points, and thereafter reasoning, and thereafter the ultimate conclusion, and the findings, and thereafter the operative portion of the order. There must be a clarity on the final relief granted. A party to the litigation must know what actually he has got by way of final relief. The aforesaid aspects are to be borne in mind while writing the judgment, which would reduce the burden of the appellate court too. We have come across many judgments which lack clarity on facts, reasonings, and the findings, and many a times it is very difficult to appreciate what the learned judge wants to convey through a judgment, and because of that, matters are required to be remanded for fresh consideration. Therefore, it is desirable that the judgment should have clarity both on facts and law and on submissions, findings, reasonings, and the ultimate relief granted. So that's how a judgment should be written. That's how these points, important aspects, are to be looked into at the time of writing a judgment. I hope it will help our learned audience in appreciating the beautiful observations made by Honorable Mr. Justice M.R. Shah. With that note, till we meet again with another case note, Namaskar.